So in this session, we're building on our understanding of sourcing, how we selected suppliers. And we get into an interesting area, interesting in many ways, one of which is it can be quite contentious. Two, it's a major opportunity with procurement. And three, it brings in very different disciplines. And this is why I kind of call it this threaded weave of contracting. And so we know what a contract is. It's an agreement between two parties for something. And I want to explore that a little bit further. But the focus today is also going to be on the contrast between these two things, the commercial lens and the legal lens. They're both very important. They're both there to serve the organization, but they have a very different perspective. So very much so for procurement, the focus is really commercial. It's how do we generate value? How do we get the best purchase? How do we get the best terms and conditions? What's the lowest total cost of ownership? And it's really about supporting the strategy of the organization. And that can be, strengthening our brand image. It can also be serving our operational efficiency. And we've seen that significantly over the last few decades. And it's really about making sure we get the best market resources, and particularly in a dynamic environment, that becomes so important. And we've seen through the many crises and disruptions over the last 10, 15 years, from the financial crisis to wars to blockages in the Suez Canal to COVID and so forth, and tariffs, that this is really important. A contract is binding. And that leads us into the legal lens. The objective for the legal side of contracting is risk mitigation. It's making sure that you have obligations for both parties, that they are legal, they're not illegal or they're outside of the law, and that we follow compliance. And that word compliance is one that keeps cropping up all the time. What you'll see about the tension is that from a commercial point of view, you're trying to really seize a deal. And from the legal point of view, you're trying to exercise due diligence. And that's where the tension often occurs in organizations. So what are we looking at? We're looking at an agreement. What's the commercial intent? How do customers and suppliers come to some agreement over quantity, over price, of specification, service experience? What happens when things go wrong? From a legal point of view, it's can the contract stand up in a court of law? What are the dispute mechanisms and so forth? What about penalties? What about renegotiation? What about escalation? So there's a lot of issues on both sides, and the contract is at the heart of an agreement between an organization and its suppliers. Now, that would imply that a contract always exists. And in essence, a contract always exists. The challenge we have is whether it's explicit, whether it's written down. And so we want a foolproof mechanism, really, for accountability of both parties, for managing expected outcomes, and what happens if there's any problems that line up. So let's think about the commercial and the legal anatomy of a contract. What are the bones of a contract? From a commercial point of view, we really want a statement of work. What is it that we are expecting to be done? So if I'm contracting with a builder, what do I want them to do? Exactly what sequence? What are the specifications? What type of materials? What type of finish? How much? When am I going to pay you? And when is it going to happen? The legal side of that is really about T&Cs, terms and conditions. And those general terms and conditions are at the heart of the legal side of the contract. It's really concerned with liability, indemnification, privileges, and any immunities. So those are the key documents that you'll see in a contract. Paper that, or rather virtual documents that support an agreement. How do we know whether we're successful from a commercial point of view? That it's cost effective and it's high quality. We meet the specification and we have a good total cost of ownership. From a legal point of view is nothing goes wrong. We don't have any risks. Risks are mitigated when they do occur, that we're not liable as a buyer for problems that arise. And how do we allocate risk? From a commercial point of view, it's about payment and performance. It's really having guarantees that if you are on time, this is the payment you'll receive. If you're late, these are the penalties. And I think the same happens from a legal point of view, although we're also concerned with the criteria for termination, force majeure, and making sure you comply with regulations. That's really important. And that's why we need the legal focus, is to ensure that whichever state or country or jurisdiction we're operating in, that the contracts are legal. And that isn't always the case. And we'll be familiar with the pre-award process. How do we identify needs? To be honest, this is one of the challenges we have in procurement. We need to be there when that initial discussion about, well, we've got a problem, how are we going to solve it? We've got a database problem, or we've got a capacity problem, or we've got a facility problem. We don't want to hear, oh, we've designed the building, or we've found the software that we want, can you write the order? Because what we really then want to do in procurement is identify how much do we need of this item, this service, or this product, and who's going to provide it. And then we go out for bids, and we evaluate those bids and start the negotiation. Once we've decided on the supplier and we've negotiated our commercial terms and conditions, we need a contract startup. Now, quite often, the danger is that the contract comes from the supplier, which means the supplier is really dictating the legal side of that contract. So we want to know what is in our best interest as a buyer. When are the startup? When are the obligations? What changes do we make? How do we close out? How do we evaluate performance? And very importantly, what about invoice verification and compliance? By that, I simply mean if we get an invoice, is there a contract aligned to that invoice? And do the two documents match? We do not want to be paying for things we haven't agreed for. We do not want to have to pay for things that we forgot to include in our commercial terms, and in the supplier contract, it's in the fine print. That happens a lot. What happens even more is that there's no contract. And we often say the only time you need a contract is when there's a breach. But that's not strictly true. We use a contract to hold people accountable and to monitor performance. So thinking about that pre-award phase, I think there are 4 key points that we really want to focus on. As I say, that planning and needs assessment, procurement needs to be involved very early. We need to be involved very early because point 2 is about sourcing and solicitation. 80% of your sourcing decision is taken at the specification. When we're determining a piece of software, for example, for our CRM system, and we say we want it to be able to scrape LinkedIn, we want it to be able to integrate with our existing CRM, and we want it to be able to generate X, Y, and Z reports, you're really focusing the specification, narrowing it down to almost exclude many providers. We don't want that. We want to at least be in that phase of interacting with the user, the person who's specifying, to say, well, let's have a look at what's in the marketplace, because then we can go out to the market and we can look at an iterative approach. Point 3 here, after we've received our bids, is evaluation, and we've talked about that in other sessions. We talked about Pew Matrix, for example. And then point 4, negotiation, an integral part of procurement, which is why we have a whole course dedicated to negotiation. Once we look at pre-award versus post-award, one of the key things is, where does the responsibility switch? And the focus in the pre-award is really with sourcing analysts, procurement, the buyer. And the focus after award is with the contract manager and legal counsel. To be frank, you would like to see a contract manager within procurement who works very closely with legal counsel, because the buyer is doing the supply market research, drafting the solicitations, evaluating, coming up with the blueprint, coming up with the basic contract terms, and then the contract manager is refining that, as we say, going over it with a fine-tooth comb, so that then the physical output is the contract against which we execute and deliver the product. Now, the challenge is, how do we compromise? How do we compromise with that tension between the commercial side and the legal side? Well, I think there are 4 elements where we can do that. Firstly, when we look at contract startup, make sure that the user, that legal, procurement, operations are involved in specifying. I mean, to be frank, this is a negotiation, an internal negotiation. It's making sure that we've got all of the criteria that are relevant. I'll give you a quick example, which is against myself. So I recently had some building work done. I used a contractor I'd used before very successfully. We didn't go through, I obviously don't have general counsel working for me, it was for my home. But one of the real challenges was that it was literally a back of an envelope contract. And when we started to have problems with builders, one of the problems I've noticed is that they don't always turn up on time, or they don't always turn up. So what recourse did I have? And the answer was 0. It was built on trust. And that's a key factor to keep in mind at that very first stage. If you don't have trust, or you've got limited trust, you need a contract. Once you've got trust, then the contract is still necessary, but it's incidental. We often say the contract is only ever used in the breach, and with high trust relationships, we resolve breaches together. The second phase where we want that integration is on the performance monitoring, tracking the time, the cost, the quality, making sure that deliverables match the statement of work, and that we're holding the supplier accountable to the contract terms to make sure that we're limiting liability and we're delivering. The third very important stage, and this is, to me, one of the dominant reasons why we must have contracts, and we must have an integrated contract and procurement process, is financial control. The majority of fraud in organizations takes place in some aspect associated with this procurement process, from choosing suppliers who may be either related or paying a consideration, shall we say, or a bribe, to making sure that we've actually received the product or experienced the service. So that's where we need very close alignment with our systems between legal, financial, and procurement. And then, of course, making changes, making amendments. What happens if things go wrong? What are the legal guardrails? And that leads us into this issue about the escalation staircase. You know, what happens when things are not fully tightened at the early stage? So we wrongly specify material. So an example is we ask for a particular type of wood for an application in a building, and then it transpires that that wood is not appropriate. It's too soft, or it's not durable enough. You know, it's not cedar, so it's not insect proof, and so forth. Or it's not teak, so it's not water resistance. So what do? We can amend documents prior to the award. So this has happened to me with building. You know, I've had a contractor come in and say, well, you specified this product for the drywall, but that's not going to be soundproof enough, or it's not going to be insulating enough. Okay, let's change that before we actually get to the contract. That's the point at which it's the easiest. So that's step one. Once you've awarded the contract, then it can become a little bit more of a problem, that we certainly need escalation clauses in the contract. We need conditions in the contract that allow us to make changes. If we get into the problem that we discover there's a fault after, let's take building again, after a building's been constructed, we find that things are falling off, then it becomes a really expensive remedial effort. And sometimes all things fail. You're left with a part completed building. You may have to seek a new contractor. And it may be that your original contractor has gone bankrupt. It may be that your original contractor was unable to deliver. But if your contract terms are tight, at least you've taken every step to mitigate the risk. Now, this is why contracts need to include the commercial and the legal side, but they also need to think about the operational life cycle. And so who's involved? The contract manager. Contract manager sits at the heart of this process, and they're interacting with legal counsel, with budget and accounting, with the legal community, making sure that we understand what the legal requirements are, clearly working with the vendor or the contractor or the supplier, and the program staff, the subject matter experts. So a contract manager is at the heart of a nexus of key parties in this process. And then how do we check that we're managing change and disputes? Do we need to have changes in the contract whilst it's under execution because the scope has shifted? So we must make sure that there's formal amendments. Now, often I've seen that contracts are issued for a particular sum, and then there are amendments, and those amendments can sometimes exceed the total cost of the original contract. In many cases, I've seen where the amendments have been 4 or 5 times the initial cost. So you hear about public works contracts escalating, and the original expectation was that it would be $10 million, but it ends up being $85 million. You have to look behind that headline to look at, firstly, why did the costs increase? Secondly, was there allowance in the contract for example, compulsory purchase of land? Thirdly, could any of this have been unexpected, or could it all have been anticipated? And that leads us into how do we resolve disputes. Firm contracts mean, you might get arguments by a supplier, but if you've got a robust contract, they will stand up in a court of law. If it has not gone through general counsel, if it's not gone through legal, you're at risk of contracts having holes in them. So you really want amicable agreement or amicable settlement, but all else fails, go to court. And that's an expensive process. It's a reputational risk as well. And then when we come to closing out a contract, which is a really important part of a contract, it's at the end of it all. Have all of the goods and services been delivered to satisfaction? Have the users given us the feedback? Has everything been paid? Have all of the financial transactions matched the contract agreements and any amendments? Making sure that we transfer intellectual property, equipment, and so forth. Again, I work in a university. Quite often we have contracts that are associated with grants. Those grants provide equipment. At the end of the grant, what happens to that equipment? Because we lose the funding, but we don't lose the responsibility. We may keep the ownership, we may have to return ownership, we may have to dispose. Those things need to be clearly defined. Often that doesn't happen. And of course, this feeds into our future intelligence. It's part of learning, it's part of how an organization evolves its procurement impact strategically over time, is that we use that intelligence, we use that experience to refine and remedy any problems. So in a nutshell, what we're talking about is that you have to be fluent in contract management, which means you have to be fluent in legalese and in sourcing. You also have to be able to make sense of operational requirements, technical requirements. You have to know who are the people to turn to, and you have to know how to orchestrate experts when you may not be an expert in their field. And of course, every expert has an opinion, and every opinion is valid but biased. So again, this is why we talk about a bilingual or even a multilingual professional. It's not a separate phase. Contract management is at the heart of procurement, and therefore contracts need to be a collaborative effort between procurement and legal.